I write because I would like these ideas to be put down in something tangible to be built upon. My articles have been cited, cases where lawyers are using them as tools to improve their clients' chances. I often have inmates who will write me to inquire about assistance in their cases. And, I'm moving to this 13th Amendment analysis and really focusing there because I think that we have a constitutional basis to really upend our system of oppression and create something new. So my legacy could be really the refocusing of the power of the 13th Amendment and all of the many programs and opportunities that come from that. That would leave me as, okay, good job, mission accomplished.
You are now part of a social experiment.
See now where my limit is. Only got no ohs.
Welcome to the program. Thank you for joining us today on the journey towards self-mastery. Our next guest is an educator, activist, playwright, entrepreneur, and criminal/civil rights attorney. He is a tenured professor at Seton Hall University. He has dedicated his life to addressing systematic injustices in the legal system. He teaches constitutional law, criminal procedure, and trial advocacy, equipping future lawyers with the tools to challenge inequities in the justice system. As a Maryland public defender, he has litigated thousands of criminal matters and won over 90% of his criminal trials. These cases have dealt with police brutality, jail medical malpractice, cruel and unusual punishment, and more. He is nationally recognized as an expert in gang prosecutions and has several published writings dealing with the criminal justice system, including double jeopardy, gang cases, teaching law students, and more. Let's welcome today Mr. Fareed Nassor Hayat to the program. Pleasure having you on, my brother.
Absolutely. Happy to be here.
Yeah, man. It's definitely been a long time coming, man. I know you're super busy, but definitely think this is an important interview. When we look at criminal law, I think a lot of times we don't even know that much about it until we have to actually deal with it in the criminal system. And I think that's definitely the wrong time to be learning, So hopefully you can provide us with just some basic information that can kind of help us navigate this system, man, that we find ourselves predominantly in when it comes to who's mostly prosecuted, who's in prison, who's everything kind of falls under, Black people in this system. So hopefully you can kind of assist us today in navigating the criminal justice system.
Absolutely.
I just want to start with just some criminal justice 101 before we begin. Just to start with purpose, like, what do you think is the purpose of the legal system in the United States? And we do call it criminal justice. So in your own terms, how would you define justice?
Well, many of us don't call it criminal justice at all. We call it the criminal legal system. And really taking that word of justice out, because you asked me, what do I think the purpose is? The purpose certainly isn't justice. Purpose is order maintenance. And, you can go to various extremes with that. Some on a more middle ground kind of space would say that order maintenance is just maintaining order in society, keeping people following the law, abiding by the rules and regulations as they're written, and, keeping peace within the space. And then there's a more, leftist kind of approach that believes that it's more about maintaining old systems of oppression and keeping people in their place in that way. Still order maintenance, but order maintenance of an old day in which folks were subjugated to status less than citizen. If that means, the ability to own property, the ability to testify in court, the ability to, be independent and free and move and travel as one wants, or raise your kids the way that you want. So I believe the criminal legal system really is a lot more tied into that rather than a concept or a question of justice.
So in terms of like how you would define justice, I know you say it's not prevalent in the legal system. How would you define it just in general, if it would be?
I guess that's somewhat of a challenging question for me because I don't know if I've ever experienced justice. I don't know if I could really point to instances in our society that are truly just. Some think that if I got convicted of murder and you gave me the death penalty, that would be justice. But I wouldn't find that to be justice when there's no accounting for how someone gets into the position to commit a murder. What their life experiences have been that, desensitize them to valuing of life and to equip them with the ability to take another life. That doesn't happen overnight. That's not something that individual often facilitates. So when we bring them to judgment day for their action that they've committed, we oftentimes, in no way does that consideration comes into play. So giving that individual some harsh sentence, life in jail or the death penalty in certain states, I don't think it's justice without accounting for what got that person there and doing something to ensure that the next group of kids don't get there.
When you teach your law students, you really talk to them about really fighting hard for, the people that they're fighting for, and to really take into account what can happen if these people do get identified in the legal system as criminals. So can you share with us exactly what that means in the legal system to be identified and classified as a criminal, and how that can affect one's life?
I'll start with my role as law professor, and my transferring from being a full-time everyday practitioner of criminal law to being a teacher of criminal law and constitutional law. And it really was the nature of the system that kind of pushed me out. It is an overwhelming experience. I liken it to being a boxer. And, at some point, it's time to leave the ring. The bruises and the bumps on top of your head at some point become too much. And that experience of waking up, walking in courtrooms, and fighting the system on behalf of criminal defendants is a very taxing experience. And either you're going to become, that boxer that's being beat up in the ring really badly at a certain point in your career, or when to retire and get out and, maybe go and teach and coach others, be equipped, but understanding honestly that there is an expiration date on doing certain levels of the work, much like there's an expiration date on the days in which you can stand in a ring and box. So my transition to teaching law was really about relieving myself of those bruises, and at the same time equipping that next generation of lawyers. And, I have to say lawyers as opposed to simply criminal defense attorneys, because, most of my class is not students who want to be criminal defense attorneys. My experience is most individuals who want to go in the criminal legal system want to be prosecutors. So I'm charged with a bit of a challenging position to instill within future prosecutors a sense of abiding by at least the expectations of the criminal legal system, following the rules and trying to operate in a way that's fundamentally fair to whoever comes before them. So that's my starting place. Next thing in the classroom, the practice of law is a craft. It's really a set of tools you get in law school to equip you to go and engage in the practice, almost similar to becoming a plumber. And this concept is once you learn these certain set of skills, obviously you're going to get more effective at executing them. But it's that set of skills that separates you from anyone else. Someone else can look at a complex plumbing situation and say, oh, I get that. But if you don't understand the angles, if you don't understand the vents, if you don't understand where hot and cold flows from and how to ensure that the system is working down the line, it's going to be a failure. So the primary role as law professor is really just teaching those tools, teaching the language of the law, and really framing your way of thinking. The practice of law is a very conservative venture. Our legal system here in America is based on, a European, largely British common law, the way they did it in Britain in the 1400s is the basis of our legal system that very much still shapes much of what we do today. There's very little that goes outside of that realm. So we're maintaining a system that was designed, if you think about those same times of what was happening in the world in the 1400s, it was an expansion upon the world to kind of dominate and impose an order upon them. So that's what I'm teaching in the criminal classes and the constitutional classes every day on a base, is what this system is, what are the rules, how you engage in it. After accomplishing that, then my role of teaching a bit of a critical perspective to challenge on some of these frameworks that we've taught, how to read between the lines and how not be a perpetrator of oppression, honestly, how not to use the law as simply a weapon against the masses of people, but really be able to use it as a shield to protect those same people.
With that being said, what do you tell them about just criminality and what it means to be a criminal, and what that brings, that title?
My writing here lately, my last few articles have dealt with this constitutional concept of badges and incidents of slavery. And what that is offshoots of slavery. We had the chattel system, put you in chains, make you work on a field, and all of those iterations. But the badges and incidents are the things that came out of that system that existed to support the system. Certain things like the inability to testify in court, the inability to own property, your body being subjected to intrusion in terms of rape or killing. All of those are incidents of slavery. Those are things that happen within the chattel institution. And then those badges are those indicators that you should be subjected to those incidents, such as your skin color. That's the ultimate badge within slavery. So that is, chattel slavery. We have this modern iteration within our criminal legal system, the prison industrial complex, that engages and facilitates many of those same things in new forms, but many of those same things. So when you ask me what is a criminal is a person who has been labeled and badged with this identity that can be subjected to certain kind of incidents of the criminal legal system, the mass incarceration and otherwise. Examples of that would be once you are convict, you can't receive student loans anymore. You can't own a firearm anymore. If you do testify in court, it will be tremendously diminished. You will be dismissed off of juries almost on first take when it's disclosed that you have a conviction. You will not be able to rent certain apartments in certain kind of communities because of that. You won't be able to receive certain kind of employment because of that conviction. So all of those are incidents of slavery that badge of conviction provides. So that is what our criminal is today. Our criminal is a person who is subjected to a continual state of second-class citizenship.
Now I know you've written about this and you've spoken about this, but I actually, asked some of my students about kind of this concept of, is there like a color or skin code to criminality and criminals, right? And one of the activities I do with my students is called the story of Jamal. I got this from former guest that I had on the podcast, and he does this with professors and teachers that are going to be teaching Black and brown children. And it starts pretty much with Jamal, wakes up, brushes his teeth, goes outside, and then the kids or the teachers got to continue the story and do a sentence for every part. And for his side, like he did it with teachers, he told me there was only 1 or 2 times out of the hundreds of times that he did it that Jamal did not commit a crime, end up in jail, or end up being killed in the story. And with the students that I've done this with so far, probably about 6 or 7 different groups of students, Jamal's never had a good day, and he's involved in crime throughout the story and everything, and involved in some stuff. And I've asked the students, like, why did you choose for Jamal to have a bad day? Well, his name is Jamal. What do you expect? I'm like, all right, so Jamal means that does he have a skin color? Yeah, he's got to be Black. So does that mean that he has to commit crime, or he's destined for a terrible life and a bad day? And, they're arguing with this back and forth, and it just gets down to, you guys had control over the narrative, but you still chose the prejudices and the identity that society has told you that Jamal is. So teachers, same thing. They had the same answers. And it's really an interesting psychological experiment that I find to be similar amongst young people and the educators and the teachers. Some of my students even said, we were nice with Jamal's story. I kind of wanted to kill him. I'm like, why'd you want to kill him? He's, it would just make the story more interesting. I think he deserved to die, because his name's Jamal. And it says a lot. Do you find with the kids that you're teaching, first year law students, that they come to school, into class with preconceived ideas and notions about Blackness and criminality?
I have to admit that students won't reveal that to me. I think I'm very outward about kind of what my political philosophies are, how I think about the law. So that kind of frankness would not occur, nor do I create a space in which that kind of mentality will be accepted in the classroom. I may more proceed with, I understand that reality that you just described, that most of us, including me and you, have these kind of mentalities that have been fed into us. And so I start with that as my starting point, that yes, that's there. How do I take you down a different pathway? And that is the critical teaching in which I try to engage. The admission that we all are subjected and have adopted many of these racist ideologies is not necessary for me in the classroom. I take it as a given, and I attempt to move students in a way of opening up their thinking without first establishing what we already know, what
Right.
what
At
you've
that point.
demonstrated you already know. And I think that creates a more conducive environment in a law school classroom for people to engage, where unfortunately they don't have to be forced to acknowledge their own biases in order to start trying to understand when they're on display and what they can do differently to address them. And, is that the most effective approach? Maybe for the classroom that day to still be able to teach criminal law or constitutional law. Yeah, do we all need a reckoning in order to truly do something? Maybe I'm not serving that particular objective as effective with this approach. But we got jobs, right? That we have
Yes,
to
sir.
accomplish that primary role, and the primary role is to teach criminal law and constitutional law and criminal procedure while empowering you to be a more open-minded, conscious, critical lawyer.
That makes sense. That makes sense. And you do that very well. In a lot of your writings, you reference the Dred Scott versus Sanford case, which ruled that Black people have no rights, which white men is bound to respect. Do you believe, like in this day and age, that holds true in practice today? And for someone like you that's won 90% of your litigations, how do you go about really dealing with a system that you identify that is unjust, finding some sort of justice to where you're able to win some of these cases despite the racism and things that are happening in the system?
In practice, versus what is the law, again, as lawyers, I accept the tools of the law and expect those people who are involved in the criminal legal system to abide by them as well and hold them accountable for that. So the framing in Dred Scott was a pre-14th, 13th, and 15th Amendment framing in which, people of African descent had not been recognized as citizens in this country. With the 13th, 14th, and 15th Amendment, that changed. And those amendments are still the law of this land, notwithstanding individuals attempt to pull away from those amendments every day. So is the philosophy of Dred Scott or the legal doctrine of Dred Scott still good law? Absolutely not. The 13th Amendment is real. The 14th Amendment is real. I mean, it was hard fought. Hundreds of thousands of people died fighting to obtain those things. And we have had tremendous advancement because of those things. One vein. There's another vein where there is a significant portion of our community, our country, that would like to act as if those amendments did not occur and that they are not the law of the land. And they would like to revert us back to a time predating those things. And they act accordingly. They act accordingly about the way that they implement criminal prosecutions. They act accordingly about how resources are divided amongst our country. They act accordingly about the way that our value is seen. And this is how that Jamal's story can exist because, Jamal is certainly a child of an enslaved person in the minds of all of us. And we present that picture and that story for him. So, yeah, in practice, there are many of folks who constantly push back. But I think there are more people who don't understand the connection between the old guard and the way that it's going on today. And that's really what my work is about. That is what I'm writing about over and over again is, number one, what is the law in its truest form and where it came from, meaning the things that we were trying to address when we passed certain laws, and then how we don't fall back victim to implementing that old guard without knowing it. There's many Black prosecutors who are doing it for what they believe are the right reasons in their heart and their desire to impact their community positively. I would suggest that, there are many tools that were designed to oppress, which makes them weapons that they use against their community, oftentimes not understanding the background or the history of those weapons. My most recent paper certainly deals with that kind of concept of the use of prior convictions against a witness who chooses to testify and your ability to exclude them from testifying almost completely with this fear of being impeached and their character kind of diminished, and how that ties to a long history of excluding Black people from testifying at all. And if they did testify, discredit them so their testimony has no worth. That is a tool of oppression that not a prosecutor in our country would not use to challenge the credibility of a defendant. And as you said, proportionally more Black defendants than anyone else. So,
Indeed.
yeah.
Indeed. Now, I do want to get into a little bit of your history, but before then, as far as lawyers goes, do you feel like it is the responsibility of lawyers to deal with the racism in the legal system and to be fighting for some of the things that you're fighting for, or like you said, is it just your responsibility to do your job and whatever it is, whether you're a prosecutor or you're in defense, to do that job and find ways to win in your cases? Or do you think lawyers have a bigger role in challenging and changing the system?
I don't know if I have any affinity for lawyers or a group identity with lawyers to say, lawyers have a special calling to do this work on behalf of justice or people. I do believe Black people have that fundamental requirement with their being. And that is something that we cannot separate our existence from, because as a people, we have been systematically oppressed, undiminished, and stepped upon. As a lawyer, no, that's not the experience of lawyer. Many more lawyers are a part of the system of oppression rather than the system of overturning that and doing something different. So, no, I don't have a particular belief that lawyers have a calling to do that which is right. Slavery was a legal system in our country for hundreds of years, and it was always wrong, no matter if it was the law or not. I do believe that this position that I have, that, starting with Black people, because I am a Black man, we have a duty to do something to improve our lot. And I believe that anybody who similarly believes those kind of things, starting with themselves, but incorporating those around us, including Black people, have that responsibility. So the students that I teach that do desire to do that which is right, to improve the life chances of other human beings, and oftentimes starting with the people who are subjected to the most oppression, yes, those people are a part of this overall fight. But I don't have any kind of fantasy to believe that law school and law students somehow have a calling to change the world for better. I think that most practice of law is to maintain the world as it is.
That makes a lot of sense. Now, I kind of want to dive into a little bit of your history and how this all came to be, man. Just really how, a kid from South Central LA turns into a dope lawyer and a dope advocate for Black people. Like, how does that happen? So can you share with us, just a little bit of your experience growing up, and some of the challenges you faced and how you were able to maneuver this thing called life?
Well, first I always pause when someone refers to my neighborhood as South Central Los Angeles, because it's really like framing that occurred in 1992 with the Los Angeles Rebellion. And prior to that, we very much were sub-neighborhoods within South Los Angeles. So I'm from the Westmount neighborhood that and you've maybe heard of Leimert, or you've heard of these different neighborhoods within LA, and that's really our framing. After the rebellion, there was this attempt to label that entire area that's south of the 10 freeway as South Central, while South Central is much more east than what that neighborhood really is. There is a Central Avenue that is a historic space for Black people in the Los Angeles area, that if anything was South Central, was that one neighborhood that was South Central, was on the South on Central. And that title has been expanded. So I really like to frame myself as being more from South Los Angeles. And if you want to talk about a neighborhood in particular, it's the Westmount area of South Los Angeles, right east of Inglewood. But how did I kind of end up this way or in this space? More than anything, the support of community members, starting with family, with my grandparents, and, folks who moved up during the Great Migration to get away from some of the oppressive spaces of, Mobile and Birmingham, Alabama, and trying to make a new day. Starting in Watts, California, and moving a little bit further west in the South Los Angeles, taking me on through kinship foster care when my parents suffered from drug addiction and did not have the capacity to provide a nurturing, safe home that could prioritize education and provide resources to live. So they took me on through foster care after a number of years of providing for me independently and really living on a shoestring budget in order to do that, through bartering relationships with local store owners and so on and so forth. So that starts, but then I had other family members, particularly my aunt, after the death of my grandmother in a tragic car accident at 19, moving back into the home and taking on me at 14 and two younger brothers and sisters and two cousins. So I had a 19-year-old move in the house to take on, 5 kids that were not her own. And at the time she had none of herself. And the amazing ability of her to somehow be successful in that. Be successful in like rearing 5, teenagers and small children. But from moving from my family space and all of the family that really did contribute to a positive space, from uncles who were in the home with my cousins, were working every day and being a model, for my grandfather buying his own home and getting the value of what it meant to be a homeowner, which contributed to me buying my first place at 22 myself. And then, buying upward of 30 houses within that time, from just that image that he gave me of home ownership, to really moving into school and having folks recognize a bit of my genius, and then showering me with resources to be able to actualize that. And, it's a funny situation, because I was blessed to have people just give me resource after resource, and give me resources before they gave the 10 other people in line resources, because there was this belief that there was something special that I possessed. And that specialness, I think, is in many of us, maybe most of us, but I was one of the few people that they could see it too. So as a result, they would move me to the front of the line in everything, from scholarship opportunities to placing me on the right teams, in the right roles, to, readjusting my teaching and my school schedule in order to ensure I got the right teachers that were actually going to deliver, to spending personal resources to provide things to me, from computers and typewriters to otherwise. So, it was a community that put me in a position to actually be able to excel, and then me making a choice to put my head down and actually do that work. And the putting my head down thing really is closely connected to how I moved from having my ultimate goal of being a gang member as a child, from, maybe 6 or 7 years old to about 13 or 14 years old. That was my biggest goal in life, was to be the most effective gang member in my community.
Wow.
Because
Why? Yeah.
Well, because, I had family members who embodied this masculinity and this aura of strength and something to be desired. They were not weak. They were not being ran over. They garnered respect from other family members, the way they responded to attack or critique, all of these things. They had friends, they had relationships, they had, and the resources was minimal, but the resources they demonstrated a way of caring for those things. If it's just the way that they pressed their clothes and they shined their Stacey Adams, you know what I'm saying? It was something magical about that. Was a desired position that I had. And, they embodied strength.
And what got you out of that mindset?
Being forced to deal with the reality of what it actually produces. At 14 years old, I had officially got put on the gang in my neighborhood, meaning, jumped in by some of my other friends and cousins and community members into becoming an official member of the gang. And my cousin, who has been incarcerated for over 20 years now, really saved my life, because, he was one of the most effective members of the gang while we were growing up. Fearless, strong, passionate, and a true leader. And obviously wanted to emulate him in so many ways. And for some unknown reason at the time, he went and told family members when I decided to become a gang member and get put on, even though he had been a bona fide gang member himself. And, I was certainly greatly offended by that. But my grandfather, the same grandfather I spoke to, approached me and asked me whether it was true. And I had decided before being approached by him that, as I said, I was going to be the best gang member in the neighborhood. And one thing I found interesting was so many of my family members would deny their involvement in gangs when questioned by like family members and things. And I had decided that I would not, that I would stand in my truth and identify myself as a gang member and be prepared to deal with the consequences as such. So my grandfather approached me and asked me that question one night while I was standing in the kitchen pressing my dicky pants with the perfect crease. When he approached me and asked the question, "Hey, I heard you got put on UG. Is that true?" And I turned to him and I said, "Yes." And he just hit me on the side of my face, knocked me on the ground, and literally stomped me into the ground.
Wow.
And, and just said real simply, he wasn't a man of many words. Ain't no UGs in my house. And walked on into the back to his room and did whatever he was going to do for the rest of the night. I pulled myself up, finished pressing my clothes. And, I was like, all right, that was the consequence. Now everybody know. You know what I'm saying? It is what it is. So I went on to school, still identifying as a member of the gang, and came home the next day, and he visited me in the kitchen again almost the exact same time. And, this is not like a one-off with my grandfather. I have at least 10 stories in which he visited me with a question that, depending on what your answer is, you will immediately get an onslaught of physical assault. And that was the reality. And I understood that was his tool of discipline. He had a 3rd grade education and owned his own business and had 7 children. And he had his tools of discipline. And this was his primary tool. Came in the second night, asked the same question. I proudly gave the same answer, and I received just as thorough another beatdown. And, I had to tell you that I was surprised about the second beatdown. I really didn't expect that. I thought there would be more of acquiescence to the reality that, okay, well, this is what he's chosen. Leave him be. Maybe get out. Something, I don't know. But none of those things actually came. That second beatdown came. And like clockwork, the 3rd day, he came right back. Asked the exact same question. And I looked up to him and said, no, I'm no longer a gang member. And I meant it. I 100% meant it from the bottom of my heart. And immediately went to school the next day and declared it to all my fellow gang members, hey, I'm no longer a part of it. And they're like, what you talking about? Oh, man, just lie. And I was like, no, I'm not going to do it anymore. And, that's a decision I made and a decision I stuck by. It was a difficult decision because all of my best friends were members. This had been a life goal for the last 4 or 5 years. And I had no alternative plan about what I was going to do instead. So, I was kind of stuck by myself, lonely, in a state of depression almost. And, I can tell you that my grandmother died soon thereafter in a tragic car accident. And I went into a deep depression from this loneliness of losing all my friends by choice and then losing the love of my life and my grandmother at the same time or contemporaneously. Man. And luckily through peer counseling and a counselor who to this day, Dr. Smith is one of my closest confidants, came and grabbed hold of me and pulled me into peer counseling and helped me rebuild both my, my spiritual self, but my mental health. And that commitment that my grandfather instilled that day that makes some choices about who you are and stand by it was who I was. So when I started making choices that, hey, I'm going to be an A student, never got anything under an A again. That's just, I learned how to just focus. I started lifting weights that year at my high school. And I can tell you, I went from pushing 130 pounds at the beginning of my freshman year to by the time I was in the 10th grade, I was bench pressing 300 pounds and, working out 4 hours a day, 5-6 days a week. And, it was an amazing weightlifting program at my high school where a guy dedicated his every day. He'd be in there 6-7 hours with the youth training us and lifting weights. And that was the first place that I developed discipline and like work ethic. Man. And like real, like tangible gain. And, muscles are tangible gain. You can see it, and it ain't nothing but hard work. And, I learned lessons of hard work through the weightlifting program that translated to every single thing else. So I learned how to stand by my truth through my grandfather's direct challenge to this identity I was choosing. I got some spiritual help and some mental health help through Dr. Smith and her assistants. And then Daryl Lott in the weight room. And the club had a simple name. Black Men Work Hard was the name of the club. He had the club literally was called Washington High School Weightlifting Club, Black Men Work Hard. And that's what I learned. Hard work, and college ended up being easy once you had those skills. You know, practicing law and getting ready for a case was easy once you had those skills. And once you had an identity and knew how to stand by who you were, you know, the skies was the limit.
Man, that is definitely a powerful story because, like you said, it could have went a lot of different ways and routes and avenues. Man, shout out to your grandfather for sticking through, and you know, your family for accepting your choices too, man. Because they could have been, you know, like, nah, you're gonna get, you know, we're gonna bring you into this life, but really accepting what you chose, I think, is very powerful and really a dope story, man. So navigating career choices, one of the things that you mentioned is that you dealing with the legal system as a youth kind of inspired you to want to become a lawyer. So what was it that you were going through just with the legal system and police as a youth that made you say that, now I want to do this now, like, and have your mind state on that?
Well, I have an article called Dignity or Death, the Black Male Assertion of the Fourth Amendment. And in that article published in Ohio State Law Review, I look at 3 instances in my life in which I had to interact with the police. And, you know, the way I frame it, right, walk this tightrope of asserting dignity or demanding dignity, or submission, that, or dignity that if you assert, it's going to be an affront to police and could potentially lead to your death, or dignity or submission, where you can just say, hey, I'm going to submit and I can stay alive. And one incident in particular that I cover in that article is what inspired me to go to law school, in which I was brutalized in front of my home by police at around about 25. I had graduated from UCLA. I was a full-time teacher in Los Angeles. I had began investing in real estate. Maybe at that time, I maybe owned like 5 to 7 places. After investing for about 2 or 3 years, you know, had made like, you know, a significant bump of money that put me in a financial secure space. Had bought myself a Range Rover at 25 and became targeted by police because, you know, not only police, but no one could understand how this 25-year-old dude from inner city South Los Angeles owned multiple properties on the block and drove around in Range Rovers and BMWs, but claim he a teacher. You know what I'm saying? So, you know, police put a target on me and they wanted to uncover what they thought was going to be some nefarious activities on my part, as opposed to I was blessed to have been in a real estate market that was growing and got in at the right time and made a couple good decisions that enabled me to grow quickly. So yeah, like I was pulled over and no, I wasn't pulled over. I pulled in front of my house after the police followed me for a couple blocks, didn't turn their lights on. And when I got out of my car, he signaled to me and said, hey, come here, with his 2 fingers. And I just really looked at him and like, maybe like that same decision I made when I told my grandfather I was going to be a gang member. I made that similar decision when the cop told me to come here. I said, I'm not walking to your car. And he responded to me, if you don't walk to him, if you don't come here, I'm going to beat your ass. Wow. And I responded to him. I said, I guess you're going to be beating somebody's ass today. And, you know, like clockwork, that's what he did. He jumped out of his car and he physically assaulted me, pepper sprayed me, and then arrested me. And I'm still confused at that point about what I'm arrested for. But later on, I get a charging document that alleges that I swung on him, that I spit in his face, and that I refused to submit after running a light and speeding away from him, which was all fabrication, just completely made up. And I was facing a criminal charge of assault on an officer for an outright lie. Had to spend, you know, I forget the exact number, but anywhere from $10,000 to $20,000 on a lawyer who ended up being like an alumni from UCLA that I met through our network, and tried to hire me a civil rights attorney to sue. And my criminal defense attorney was able to be effective and through logic and his masterful skill to get the case dismissed. But I wasn't able to hire a civil rights attorney. I couldn't find any civil rights attorney that were willing to take on the case because they said, hey, you don't have any broken bones. You don't have any black eyes. You just got beat up, but you're okay. And that experience of like a lawyer that was able to like really saved my life in many ways. And getting that case kicked out, to me not having the ability to find anyone to sue on my behalf, inspired me to want to leave real estate, honestly, and start practicing civil rights law and criminal defense. And so I applied to law school, got in, and there it is.
That is powerful, man. Especially wanting to do something about it, not just accepting. Because a lot of us just accept that, the way that we get treated by the legal system and just say this is how it is. But I think it takes a special person to be like, nah, I want to change this and I want to be able to impact people going through what I'm going through. So, definitely kudos to you for coming to that realization and having, the mental fortitude and the will to be able to do that, man. I think that's extremely powerful, man. So, you talk about just the legal navigating the law path with your students a lot as well. And one of the things that you talk about too is the bar exam difficulty that a lot of Black law students have. I looked at some data and it said only 57% of Black students in 2022 passed the bar exam. And I know you started a no-cost bar program to help students take the bar exam and take courses for it and everything. So what was your experience with the bar exam, and what do you see some of the difficulties being of Black students taking the bar exam that want to become lawyers? I
was absolutely blessed. Those same discipline skills that I learned at the weight room translated to bar prep. Working out 4 or 5 hours a day, lifting weights, made sense to do 12-hour days of preparing for the bar. And that's what I did. So I had discipline. The key is discipline. Literally, that's just the key. And my discipline goes to, doing curls and doing bench press, and translating that to sitting at a coffee shop for 6 hours and then going to class and so on and so forth. So I passed the first time, and I passed the first time without much anything beyond what every other law school student normally gets. But the key was, I turned on early enough at 14, 15 years old that my skill set was there and adequate. And my discipline was there in order to put all the information in my head. So what I learned as being the interim academic dean over at City University School of Law was that we were dismissing upward of 30 students a year at the law school. And what I found by looking at the data was that we could identify who those students were, and we should develop plans in order to address it. The bar exam passage rate at CUNY had been dropping steadily for the last 5 years. And when I started talking to students in the role as academic dean, I started finding that many students were piecemealing together bar prep classes. Former students, let me get your material, I'm going to study it and whatnot. And, or 2 or 3 different things, trying to create the perfect bar prep program for themselves. And while I appreciate that effort, why go and recreate the wheel when people have studied the techniques that it takes in order to pass the bar? Why not just listen to what they say and do what they say? And it's because no one had $3,000 to pay for the class. Many of our students were working in the summer, in which, again, because I had this real estate success, after I finished law school, I didn't go anywhere for 8 weeks. And I didn't have to worry about paying my mortgage. I didn't have to worry about eating. I had the money coming in from real estate. I was good. But most, first generation law students don't have that experience. They got to come up with that $2,500 for rent while contemporaneously studying. So that means they need to go work 40 hours in order to do that. So they have to work to pay for the class, or they'll pass on the class. So just that kind of thing. I actually got with some folks in my office. I realized the money that we were spending on bar prep at the school, but students were still not passing at a high enough number. So reorganized that money and was able to take, I think it's somewhere around $250,000 from our budget, New York State funded budget, and buy bar prep classes for our graduating students before they graduated. And, end up working it out. We had upward about 250 graduating students, including our evening program. So every student got a fully paid bar prep class. I was able to negotiate the price down from $3,000 a class to somewhere around $1,000 and something a class. And every student got the class. And the numbers were clear. If you did 70% of the prescribed work, 90% of the students passed at that rate. So that became my marketing ploy for the students. We're going to give you this class, but you have to find a way to do at least 70% of the work. That's what we did. And we moved up the bar passage rate that year by providing that class and giving clear expectations. That's one thing that I learned, that we were doing all kind of things prior, but no one was telling the students how much time it actually took in order to pass. So, you give them the resources, but you wouldn't say you must put in this amount of time this way in order to be successful. And that's what we did differently. And our bar passage rate went up 14% higher in 1 year, just with that program and that clear understanding what students were expected of. And I guess the larger point is, it's not that we have a failure on capacity in any way. Some of us may get to the starting point unprepared. And obviously that means we're going to have to do more in order to be successful. But, many of us have gotten to this starting point overcoming so much more than the vast majority of law school students will ever see. Those people who come from poverty and come from challenging positions have already mastered how to overcome. And it's about taking those overcoming skills and translating them to bar prep, or to the practice of law, or to the many other different things that we do. And we have to provide those frameworks for our students, for young people, and sometimes some of our colleagues who are our own age, for them to be able to be successful. Because it's not a lack of capacity.
Yeah, that makes a ton of sense, man. Again, kudos for you for putting in that work with the students and, providing them with a life-changing opportunity, which I'm sure, after kids fail the exam a few times, they get discouraged and things like that. And some of them may not become lawyers. So That is dope and very deep work right there. Other thing that you do for first year students is you really try to navigate them through the criminal justice system and having them have a deep understanding of what it means and things of that sort. And you emphasize a people-centered approach to teaching it, and then also an approach that infuses rap. So I thought that was very interesting. So what do you find to be the importance of those two things?
Honestly, it's not my ideal. Professor Derek Bell and Paul Butler and, many other black male law professors who teach criminal law had the same kind of realization. And it's funny because I had it actually independently. And once I started doing it and started doing the research, like, hey, let me figure this out more, I learned that other folks are doing it in their classrooms as well. And, as I know, like, rap music is the voice of the people. When you get outside of the sensationalized kind of branded stuff to be played on the radio or videos, you have real voices of the people telling the story from the ground. And if you listen to it so many times, you're going to hear them talking about very complex legal doctrine with no legal training. And you're like, how do normal everyday people get that? Well, it's this understanding that if the law is correct, it's supposed to make sense to the people. I use the example. So in my class, every single criminal law class starts with like a plane of music. So you walk in and it's just bumping in class, and the lyrics are up on the screen for you to kind of listen to the lyrics and see them. And then we're going to discuss whatever area of law we're studying on that particular day. We're going to actually discuss it in relationship to that song that's playing. So a great example is Biggie Smalls' Give Me the Loot. And in that song, Biggie Smalls is talking to his alter ego to like engage in these armed robberies of folks on the street for loot, from your earrings to your rings to your jackets and so on and so forth. And in the song, Biggie is training this young version of himself to rob without a regard for human life. Like, if they pause just a moment, pow, kill him. And, what Biggie is describing is the concept of felony murder. And this is something that I teach in criminal law. Felony murder is a murder that occurs in the course of conducting a felony when the objective was not murder. And in the law, you receive the same penalty for felony murder that you'll receive for intentional first-degree murder. And the rationale of the law is that because of your extreme disregard for human life, while engaging in an intentional felony, we're going to raise your culpability, your mental culpability, to the same level of intentional murder, and thus give you the same penalty, life in prison, or in some instances, the death penalty. So Biggie Small gets that in the song because he's demonstrating this total disregard for human life and his willingness to kill to simply get your purse. The problem with that doctrine is that, much like in his song, you have an you don't have someone who has that same culpability as Biggie Smalls. You have a third party person who's brought into it without really understanding the ramifications of their actions. So if you are going to engage in a robbery with someone, you're going to be the lookout standing outside, and they're going to rob and kill someone in that process. Felony murder changes liability over to everybody who was involved in it. So that person standing out as the lookout will also get life in prison.
Wow.
So, there's all kind of huge news stories about folks who didn't even know that people were going to commit a robbery. And, that becomes a issue of fact. And, proving that you didn't know when you drove someone to the store, you didn't know they were going to go in a liquor store and rob. That's if you're believed or not. But nonetheless, you're going to have their same penalty, which would be life in prison or death. So that use of Biggie Smalls, Give Me the Loot, enlightens students that, number one, this is not a concept that is foreign to you. Number two, it's not too complex for you to get. And number three, people on the street who this kind of law is affecting are not so ignorant that they can't get it either. So your job at lawyer is not to be up at a position here, but to be able to talk to people on the same level where I'm going to use the words felony murder, mental culpability, the causation that you were the proximate cause of I'm going to use all those words. And Biggie is going to use the words right here. And it means the exact same thing. So if you can get students to understand that, that's one thing that's going to help them understand the law. But number two is going to overcome this imposter syndrome that somehow I'm not supposed to be engaging in discussion of these highly complex legal doctrines. Biggie can engage in them. Why can't you? So that's really what the approach is. And I do that throughout the entire semester, every single class. And I've culminated my final exam multiple times with rap songs that are connected to people's criminal charges. And obviously we know in the news right now, multiple rappers who are being charged with crimes and their rap music is being used against them. So it's kind of the exact opposite what's going on. But, rap music is very much a big deal in the law right now.
Indeed, man. That is definitely a powerful way of looking at it. Another thing that you talk to your students about is plea deals and trying to advise their clients not to take plea deals. So for the average citizen that doesn't even know what a plea deal is, can you share what that is and why you advise against taking plea deals?
I advise to be prepared to go to trial, and that a plea deal is certainly not your first option. And, it's something that only comes when it's truly your client is guilty and it's to their benefit. But a plea deal is a waiving of your Sixth Amendment rights and a complete admission and a waiver of your Fifth Amendment rights. So the Sixth Amendment right is your right to trial, a right to call witnesses, a right to an effective lawyer in your trial, a right to testify. You're waiving all of those rights when you plead guilty. And those are constitutional rights that are bestowed upon you under the 14th Amendment due process clause that gives you these rights. So, that was our discussion beforehand of who has those rights. Everyone that are citizens in this country have those rights. And then your right to against self-incrimination. So when you plead guilty, it is an admission of guilt. So you're waiving your Fifth Amendment right against self-incrimination. So explaining that and understanding what that means. And that's at odds with the fact that the government, the prosecutor, the state has a responsibility to prove that you're guilty beyond a reasonable doubt of every charged crime and every element of every crime. So when you waive and plead guilty, you give all that up. They don't have to do that anymore. You've agreed that it's not necessary. The problem is that, why plea bargaining is problematic is because it's not about whether one is guilty or not. It's really about just moving the system along. You being a clog in the system. You get charged. We charge you with something that carries 20 years. We bring it down to something that carries 1 year, and then we're going to give you a sentence on this 1 year thing. So you're going to plead guilty and keep on moving. But the truth of the matter is the crime that you truly committed or that should truly be charged is only the 1 year crime anyway. And they've charged you this higher crime in order to pressure you to plead guilty. And the Supreme Court has said that's okay, that the prosecutor can charge you with anything that they believe they have a likelihood of proving. Not even proof beyond a reasonable doubt, that they have a likelihood of proving. That's called probable cause. And so many people plead guilty, not because they're guilty, but because they have this fear of a greater penalty. And then they have this out that seems like a less penalty, but it becomes a badge. Remember, it becomes this framing of you as convict forever. So it's going to close all these other doors, these collateral consequences of the conviction. And people do that oftentimes thinking they're being helpful to clients, when like the truth of the matter is, if you are a competent lawyer who really puts in the time as a criminal defense attorney, many of these things will go away. When I was a public defender, you would get 30 cases a week as a public defender on doing district court cases, misdemeanors. And I had got to the point within a year of practicing that I would show up to court with 30 cases on my docket and demand trials on all 30 of them. And 27 of them get dismissed.
Wow.
Because the prosecutor's not prepared to have 30 trials. And, you know, I'm not playing it. Well, I got a great deal. I don't want your great deal. I want you to prove it. And so what happened in that space is that the prosecutors start getting rid of all the nonsense cases because they don't want to sit there. You know how long it's going to take to have 30 trials?
Exactly.
So they're not going to have those. Now, you have to demand trials and be prepared to actually try them and have winning arguments and so on and so forth. So that's a lot of work on your end, on the front end, to be able to do that. But once you've done this thing a little while, you start knowing the cases you're going to use. You can like take the facts and really put together arguments pretty effectively. So then I'm only left with 3 cases. Those 3 cases are cases that are most likely more legitimate. The prosecutor ain't going to get rid of these 3 because there's a real victim that we really have some evidence.
Right.
And, you know, those are the 3 I'm willing to try. Most likely 2 of those are going to get kicked out. And I'm only going to try 1 case or 2 at the most that day. So if I've gone from a docket of 30 clients to a docket of about 2, just by simply being prepared for trial and demanding trials, that's what a modern iteration of abolition looks like. That is working toward upending the system by demanding trials. And all 27 of those clients got the best result. Their case is dismissed. They can get it expunged immediately. It's no longer a badge. And those 3, I won 90% of those cases. So, you know, that really was my approach. I say my approach wasn't plea, because people who plea regularly have favorable relationships with the prosecutor, and the prosecutor likes working with them. As I said, I approached it as being a boxer. They didn't like working regularly with me, and they weren't going to give my client a good plea because I came in. If they're going to give me a good plea, they were only going to give me a good plea because they knew they would likely lose. And guess what? I don't want your plea because you know you're going to likely lose. Let's have a trial and you go ahead and lose.
Yes, sir. Yes, sir.
I didn't get good pleas, unfortunately, for my clients. But I did take a lot of them to trial and won for the vast majority of them.
That's dope, man. Thank you for explaining that, because I think that can be very tricky. You know, if you're dealing with 25 years to life and they tell you, well, if you plead, you know, guilty, we'll give you 10 years instead. Like somebody might look at that as a win, but guess what? You might beat the 25 years to life. So
yeah,
you know
if
what
your
I mean?
lawyer is competent, if they've done the work, if they've investigated the facts, if they can sit down to you and say, these are the 5 shortcomings of the prosecutor's case. This is how I'm going to be able to demonstrate it to the jury effectively. And this is why we're going to win. Not because we're going to beat that. I don't want to hear you tell me I'm going to beat that. I want you to tell me how we're going to beat it, because you've thought it through. You've done the work. You have a plan of success. And if you don't go to trial with a person who can't tell you the how.
Yeah, that very powerful. Another thing I think that important that you mentioned is about probation. You mentioned that most people violate their probation within months of being placed on it, and the violations are pretty simple kind of things that people don't understand.
Technical violations.
Yeah. So what is it that you think that some of these people are missing from understanding?
Well, number one, they're missing that probation is designed for you to violate. They'll give you these parameters. You give somebody who has been a drug addict for the last 20 years a parameter that they're going to have only clean drug tests. We know overcoming drug abuse is not something you can just say, hey, I'm not going to use drugs anymore. So if that is a parameter of for a client who is a drug abuser, they're going to violate their probation. There's no question about that. If you have a person who's homeless with no resources and they have to get to the courthouse 3 days a week or 2 days a week to check in with a probation officer, but they don't have the resources to get there, they're going to violate their probation. You know, if you have a kid, you know, a youngster who honestly has not done well in school, and then you tell them they need to show up with a 2.0 by the end of the semester, but their average is a 0.5, and that's been their average for the last 2 or 3 years, they are going to violate probation. So the problem with probation is that parameters are normally set up that are not designed to be successful. They're fantasies that somehow you're going to be able to do these things. If we set up parameters that are penalty oriented and really set up in a way that we're going to provide the resources in order to be successful, maybe people can be more successful.
Right.
The other thing is that probation oftentimes is a negotiation where you're coming to a negotiation where you're not getting a fair exchange.
Right.
So you're going to agree to things like, I have had guys agree to stay away orders from the house that them and their partner live in when he has nowhere else to live. Now he know him or her going to be back on a good page in a few weeks, and he's going to be back over there because that's where he lives. But he has to stay away over. So they go get into another argument, no physical exchange, just an argument, and police go show up and he's going to be arrested with a violation of his probation. So these are all things that, already understood from the beginning. And what happens when you violate your probation is that time that's suspended over your head. The way probation works is I'm going to sentence you to 2 years. So I'm going to put you on probation for 2 years. If you violate your probation, I can give you those 2 years. I'm going to let you go home today. But if you don't violate your probation, no jail. You violate your probation, you're going to jail up to 2 years. So it's an easy way to get that 2-year conviction when they couldn't even prove the case in the first place.
Man, that is interesting that you just mentioned that, because I was thinking about a case that you wrote about that you mentioned where you got your client to not take a plea deal, and his other friends that were involved in the case all took plea deals, and within months or whatever, they were all.
About that. I don't even remember writing about that one. I know about this. Where did I write about that? I do remember.
Or maybe you told me about it. I'm not sure, but I did make a note of it. And you mentioned that the rest of them, within whatever amount of time, they were all locked up for violating the probation and everything, while you got your client out of the circumstance that they were in. And
we went to trial. So him and his 4 co-defendants were charged with a robbery. 4 of them pled guilty and got probation, suspending 15 years over their head for each one of them, because robbery carries 20 years in Maryland. They had 15 years suspended over their head. It took about 2 years for us to go to trial in his case. And when we went to trial, 2 years later, all 4 of them had violated their probation and was serving sentences up to 15 years.
Wow.
I do his trial, and in cross-examining the witness admitted that one person robbed him, and he had no idea who those other 4 people were. They had nothing to do with it.
Wow.
That is what the witness said. We get a not guilty on his case. So that means that there were 3 individuals who pled guilty to a crime they had nothing to do with, according to the witness, the victim, and they were serving sentences up to 15 years. Yes, my client had competent counsel, but also my client, because he had no prior criminal record, was able to get out on bond, while those other guys couldn't get out on bond. So they pled guilty because they were going to be sitting in jail waiting 2 years to have a trial.
Right.
So they said, hey, I can just take this probation, and 2 years, my probation is over. But instead, their probation was violated within those 2 years. My client walks away, no criminal record, free, and those guys are serving up to 15 years for a crime they literally did not commit.
That's terrible, man. Definitely a learning experience for people just in that space to understand the dangers of, the plea deals and how they can come about, man. So appreciate you writing about that. So I know you were doing some cases in Maryland for a while, and I looked up some data in Maryland, and I was really surprised, man. So Black people make up about 30% of the population in Maryland. About 72.4% of the prison population is Black. That's the highest percentage in the country, apparently. So why is this happening at this level in Maryland? Like, what does that say?
Well, it's interesting because it's connected to the thing that we just discussed. In Maryland, they have this speedy trial rule called Hicks, that you have to go to trial within 180 days of your indictment. And I practice primarily in Prince George's County, which is the most Black county in all of Maryland, and in Baltimore City. Those are the 2 biggest Black counties or areas in Maryland. And I think, their populations is 60 and 70% Black for both of those spaces. And in both of those spaces, that rule Hicks that says that they must go to trial within 180 days is just always waived. Always. Where people will be in jail 2-3 years before they have a trial. When I started practicing in areas like Howard County, which is largely white, and I think maybe about a 15% Black population, they don't waive Hicks ever, and you go to trial within 180 days. Why that's important is because if you're going to be held for 2-3 years prior to trial, you're going to end up pleading guilty. While if you know you're going to have a trial in 6 months, you will say, hey, I didn't do it. I'm going to sit through this. So I would suggest that by design, we are not expanding the courthouses in places like Prince George's County and Baltimore City. And thus we are holding more people in, getting more people to plead guilty, because in those counties, because they're Blacker, we are able to have a little more success with juries because there are more people on the jury that look like you, that can relate to your experience and understand why you're not guilty. So there's some structural things that occur that make it more conducive to pleading guilty. The other thing, so I would say that, and then there's a book called Locking Up Our Own, which is by James Foreman, and it's a great book to demonstrate how once we get Black people in the role of government administrators, judges, prosecutors, mayors, and everything else, that they oftentimes do the exact same thing that white folks did in those roles, because we have that same training. We don't have that critical lens bestowed upon us. We haven't done the work to see how we deal with our criminal legal system differently, how we can understand that hiring 100 new police officers at $150,000 a year is not better than spending $40,000 per former inmate to ensure that they have job training and a job making $40,000 and making sure they don't go back to jail. So we are not comfortable with that resource shift. We think that that is giving these criminals something for free, when the truth of the matter is we're draining ourselves by putting more money in the criminal legal system, both in prosecution and in jails, than trying to address the problem. There's a constitutional basis for reparations, and that's what I would frame it as, that we provide reparations to improve the life chances of these people who, by design, we have put in the position of being unsuccessful in society through education and all drugs and all the other things that we permit in their community. Let's be clear, local drug dealers are not the cause of drugs being in our neighborhood. They are not moving these things in the volume that it's impacting our community. These things are being permitted to come through our ports, to be delivered. AK-47s and 9mm aren't being manufactured within our community, but they're there. Sir. So, there is a disconnect about doing effective approaches that can actually address what's happening. And then, we're taught to have a disdain for poor Black people. And that's what's happening in a place like Maryland, where it's a lot of success. That's one of the reasons why I really love being in Maryland. You don't have to be ashamed to be a successful Black person in Maryland, because there's so many places which you fit right in, that the community is that. But we often develop a disdain for those folks who are struggling and forget that much of it is not their fault. There can be all kind of poor decisions, but if we put you in a position where all you have is poor possibilities, you're going to make a poor decision.
That's a fact.
That part of it, we certainly don't accept any accountability for at all.
That is a fact. New Jack City was popping up in my head when you were speaking, with Wesley Snipes saying they don't make Uzis in the hood, right? So another thing that you've written extensively about is, the gang prosecutions. Do you believe that RICO laws and the Rule 609 that you wrote about are inherently racist, or is it the way that these laws and rules are being applied in court?
No, they were made for the purpose of subjecting Black people back to the condition of slave. They are race neutral, meaning that it don't say that on the front end, but the primary drafter of both of those rules is a guy named John McClellan. He was a senator from Arkansas for over 40 years. And prior to the Civil Rights Movement, he was well known as a staunch segregationalist. He is a bona fide racist. And these are laws that he was the primary drafter on, that he led the charge. His tough on crime rhetoric led the charge on. And, in the latest paper that I'm writing, I really uncover his racist history.
Mhm.
And, when we talk about RICO, don't nobody credit where it came from. Imagine that. Imagine like using a tool that was made by someone with an objective and you don't know what their objective was. So then you're like, oh, that's ridiculous. But no, once you realize that the man who was the primary drafter was happy to be called a racist. He objected to the confirmation of Thurgood Marshall and every black judge that ever was moved to be a federal judge. He authored the Southern Manifesto, objecting to Brown v. Board. He objected and voted against the anti-lynching bills in which black people were being lynched. He stood in Congress and objected and argued against them. He used racist stories about black kids called midnight on the House floor. The man's a racist. There's no other explanation. And so knowing who he is and knowing that his race neutral, I'm not going to say race anymore, but I'm very much going to accomplish the same goal objective, is what RICO is infused with. And it is what Rule 609, which is the use of prior convictions against witnesses when they testify, is infused with. So yes, these things, I frame them, I take them past the concept of racist, but I call them badges and incidents of slavery that are designed to subjugate black people back to the condition of slave.
So you stated that there is an institutional false narrative in our society that young black men are intellectually inferior, inherently violent, and more likely to commit crimes than white people. You provided a lot of data that suggests otherwise, even with the gang stuff we talked about, that there are percentages of white gangs and that don't go accounted for when it comes to the law and things like that. So do you think this narrative influences how white people respond to cases like Trayvon Martin, Ahmaud Arbery, and even the recent cases of, all the police killings? We can just talk about those things. But the recent case of Jordan Neely, which I found to be very interesting in regards to what people had to say about that case and how Daniel Penny is almost being celebrated like he's a hero or something.
he just got a job as a executive with no experience. He is being congratulated and celebrated.
Yes. And he raised $2 million in crowdfunding, which I found to be interesting as well. Like there's this way that, white folks like pour money into a lot of these people. And, he joined Trump and JD Vance at the Army Navy game, and he's almost celebrity status at this point. And like you mentioned, he was hired by a Silicon Valley firm with no experience. And they said, they're going to train him and everything. So, just had some thoughts about what you think about that. Because I know if it was the other way around, this would not be happening.
What that case in particular demonstrates is an age-old, again, badge and incident of slavery, that black body does not have no value. And that, during the time of slavery, killing a black enslaved person was not murder. It was destruction of property. And it was the owner of that enslaved person who could seek recovery from this this aggressor, this person who killed a human being. And that was the only recourse for that individual person who was killed, his family and otherwise. There was no penalty associated with that. There's a case out of North Carolina many years ago where a black person is killed by a poor white guy, and a black guy was enslaved. He had a non-enslaved wife, and the white guy was harassing his wife and sleeping with her. And the enslaved person said, if you mess with my wife again, I'm going to F you up. He gets into it with the white guy kills him. And in North Carolina, the white guy is tried for murder and he's found guilty and sentenced accordingly. And on his appeal, the court essentially finds that the appeal was granted and the case was dismissed. Wow. And the finding was that this black person affront to this white freedman was justifiable, that his killing of him would be mitigated to a lesser form of harm because these words that he said to a white man elicited the result that he got. And that is, law now today, that your killing of a black person can be mitigated down based on them being an affront to you. And mitigated is like you still have some criminal liability. In the McNeely example, there is no mitigation. He's found not guilty. But this isn't the first time that this has happened and been in big time news, in the case of, I can't even think of the name of the case right now. But in New York, 30, 40 years ago, guy on a train, he's approached by 4 black teenagers on the train, a subway, and they say, "Give me $5."
Hmm.
He pulls out his gun, he shoots all 4 of them.
Wow.
He stands up, he walks over one, and he shoots him in the back, paralyzes him for the rest of his life. And
Wow.
then he runs, he jumps off the train, runs, he goes up to Connecticut. He gives multiple hours of a open statement to the police, and he explained why he did it. He said he was tired of these people harassing. He's been robbed before, and he said, "I intended to kill him."
Mm.
Walked over to make sure he was dead. So he gets charged with attempted murder. And the jury finds him not guilty here in New York.
Mm.
And it was called jury nullification because when he walked over this individual who's no longer a threat to him and put a bullet in his back, there could
Right.
be no self-defense. This person is
Right.
on the ground. You've articulated that your desire was to kill him. But the jury in that instance found that his behavior was justified, self-defense. And that's the same thing that happened in McNeely. Nothing has changed. The value all the way back to prior when black bodies can be killed for affronting words. Black bodies can be killed that exact same way. And not only by law enforcement, but anybody who's been deputized with the cloak of white supremacy to do the work of white supremacy is keeping black people in their place. And that's the law today. That's the law today, where the mitigation is the law and is reasonable. Is it reasonable to kill this person under the circumstances? That's what the jury found in the McNeely case, that it was reasonable to kill him. Getz is the name of the case that I'm thinking about. That's what the jury found in Getz when he shot those 4 young boys. And the difference was they said, "Give me $5." Were they aggressive in their request for $5? Maybe. Did they make a threat? Did they show a weapon? Did they attack him? No. But his actions were justified. So our value of our bodies, our humanity is diminished. And we have a criminal legal system that has been structured to okay that. And it will continue to okay that.
It's funny that a lot of that case kind of reminds me of some of the work that you're doing, because the minute this happens, they go into, Jordan Neely's background and how he has, prior cases of assault and things like that. And it almost criminalizes him and makes you think, well, he probably deserved what he got. And, you don't even look
That's
at
the badge.
the
you see the badge?
Yeah.
The badge diminishes your being.
Mm.
And then the incident of killing black bodies is okay. That's the badge of his criminalization, is the badge, and the killing of him is the incident. That is slavery. That is our chattel institution. And that's what you saw.
So looking into I want to be positive and optimistic about the future here. How do you think change, starts, or, 100 years from now, that we're not repeating this type of cases in the legal justice system, and people can actually view black people as human beings and actually think about a case and say, well, what really happened? Was this person in the right? Did they deserve to die? Do you think that things like this have the ability to change in the future, or is this just going to be a consistent struggle just to find humanity in black people in the legal system?
I believe in Afrofuturism. And, Octavia Butler is our guide with this kind of concept that our reality is for us to create. We have seen an effective creation of reality by white supremacists over the last 20 years, the way that they've taken our Supreme Court, the way that they've taken the presidency, the way that they've taken the Senate and the House, the way that our communities are rampant with their leadership. They didn't do that overnight. They did that in response to our civil rights movement that had actually moved the needle. And instead of putting their heads in the sand, they figured out how to overcome all that we had accomplished. And they have done a masterful job in doing that. But I can tell you that I am of the opinion that we are more equipped to do that kind of work. But we have to be envisioning those possibilities. The civil rights movement did not happen without planning. The legal aspect of it, Charles Hamilton Houston and his students at Howard University laid that out, and they executed it over a 20-year period. all from A. Philip Randolph to King to others, all, A. Philip Randolph, we get on the front end of it, of planning out what a civil rights movement will look like. We've done that kind of planning. So now it's time for us to go and hit the lab to do that exact same planning. And you put our number at 100 years, we got to have some 25-year kind of check-ins of how much of that goal did we accomplish if we intend to get there by 100. And much like they just accomplished this goal of taking the Supreme Court, and they're about to try to flip things, and we'll see how successful they can be, we can do that same thing. And, and hopefully we can be more effective than we were with the abolition of slavery. Maybe we can be more effective when we overcame Jim Crow. Maybe we can be more effective than we were with our civil rights movement. But each instance in which we've done this work, we have moved the needle quite a bit. And
Yes,
you and
sir.
I are sitting here as two college-educated men who educate the youth, who live in positions of privilege, who, the way we met is because our children fenced together.
Indeed.
So as it relates to the movement that has occurred, we are testaments that there has been some success, and we truly can continue to further that with the work that we're doing. And I think the big thing that we have to do is envision with tangible plans on how to get there.
I think the struggle definitely continues. And one of the things I always say is that, the ancestors didn't fight so we can just chill and enjoy what we have, but there's still a lot of fighting, and to continue their legacy and respect their legacy is to continue to work so that our kids and grandkids can really, enjoy some of the things that they fought for, not for it to be regressed. So I think we got a lot of work to do, which,
absolutely.
you're a huge part of. So thank you again for just, being part of that work and doing work to change the system, and not just a complainer that does nothing but complains about it, but actually getting their hands dirty. So appreciate that. And, before we leave out, when we think about legacy and the work that you're doing, you're a father of two young Black boys, and just from, a lawyer perspective, but also as a Black father perspective, what is the legacy that, you're trying to create with, your work and your life pretty much?
As it relates to those boys, obviously financial independence, a level of intelligence and know-how, improving on that which I got from the resources that were provided to me, and a means to ensure that they continue to move this plan forward. I write because I would like these ideas to be put down in something tangible to be built upon. My articles have been cited, cases where lawyers are using them as tools to improve their clients' chances. I often have inmates who will write me to inquire about assistance in their cases. And, I'm moving to this 13th Amendment analysis and really focusing there, because I think that we have a constitutional basis to really upend our system of oppression and create something new. So my legacy could be really the refocusing of the power of the 13th Amendment and all of the many programs and opportunities that come from that. That would leave me as, okay, good job, mission accomplished.
That is definitely powerful and deep work again that you're doing. Before we close out, do you mind leaving us with your favorite quote and what it means to you?
That's a tough one, man. I would immediately go to Malcolm. Hajj Malik Shabazz would be a space that I would go, but I don't know if I can offer a particular quote.
One of them I saw in your writings a lot was a threat to injustice anywhere is what was that one? A threat to justice anywhere is a threat to injustice everywhere.
Yeah, and that's Martin though. That one was particularly Martin. I think you got that maybe from a due process is dead argument. Absolutely. But no, I don't know if I have a quote that I would say does it for me, or one that I'm in a position to share right now. But I appreciate it.
No, that is all right. Definitely appreciate your time, man. I know I went a little above and beyond, but I was definitely getting some valuable gems, and I didn't want to cut it short, but I still feel like we got to do a part 2. So definitely appreciate your time on the program. And listeners, definitely check out some of Mr. Hayat's writings, especially if you are in the realm of law or becoming a lawyer or anything like that. I think this is somebody that you should definitely be paying attention to. And again, if you're not educated on the criminal law and legal system, which I think all of us should have some basic level of education, hopefully this interview has helped you a little bit. And then, Mr. Hayat, if people have questions or want to know a little bit more, where can they find you?
I'll give you all my email address. It is Fareed Nassor, that's Fareed, FareedNassor@gmail.com. FareedNassor@gmail.com.
There it is. There it is. Thank you for listening, everybody, and definitely check out Mr. Hayat's work. And remember, your mind is the most powerful tool in the universe. If you can think it, you can do it. If you believe in it, you can be it. And if you fight for it, you can have it. The world is yours. This has been your host, Mr. G, and I will see you next time on MasterMine.
So every day I'm going hard. I'm talking business, bank accounts, and credit cards. And somehow we defeat the odds and making sure that no one starves illegal. All you had to